Judge, as fascinating as your growing up years in Montgomery were, they had to come to an end. And we want to move now to the next period you have described as growing out. For you, these would be the years between 1965 and 2006, when you chose to go far away from your little community in Montgomery, Alabama. And I believe when we start exploring your journey during this phase, we will start to secure some evidentiary basis for your self-assessed gift back to God. That is, your having made a difference. Let's remind you first how you have described that phase of growing out. This is a period, you said, of expansion, expanded vision, outreach, responsibility, labor, and girth. During that period, we had more choices, more control, but we also assumed heightened risk. Our losses were more enduring and less remediable. Growing out was our opportunity to treat those self-inflicted wounds we received during growing up, and to inoculate ourselves against the challenges of growing on. As we grew out, our questions were reduced by a refined sense of the possible. Our judgment spent time with our mirrors, and keen observation of the successes and failures of others sharpened our goals. As growing out continued, parenthood modified our taste for risk and waste. And because we no longer saw time as endless, achieving objectives assumed more urgency. Now, necessarily, these years for you are fairly extensive because they will include your higher education, your career, your marriage, and parenthood. So let's take it in phases. The first phase, of course, is your period in college. You chose to attend a college that's now more universally known because of the vice president-elect, the infamous Howard University in Washington, D.C. Some would characterize it as the nation's most elite, historically black college, but there are many, many objections that would be made to that appellation.
Absolutely.
So start by telling us a little bit about your decision making. What is it that made you go from Montgomery, Alabama and the laboratory school at Alabama State to Howard University in Washington, D.C. in the fall of 1965?
The first decision I made was that I was not going to attend a college in Alabama or in the South. I wanted to go beyond that environment, to expand my own horizons, to meet new people, to express my independence, and to open other doors. So that was the first decision.
Was that a decision made on your own?
Oh, yes, absolutely. It was a decision made on my own. I had by then seen the xenophobia that can set in when one does not leave one's hometown and just simply stays and stays and stays. I had seen others who, in my judgment, had been deprived of opportunity by staying around, especially those who had the opportunity to go away. I had little axioms that I said to myself. I didn't want to go anywhere where everybody ate grits, and I didn't want to go anywhere where I could bring my laundry home on the weekend and do it.
Well, you certainly couldn't consume grits in Washington, D.C. between 1965 and 69.
No.
And there was no convenient relative to do your laundry. How else did Howard University in Washington, D.C. meet your expectations during your college years?
Its status as a capstone of excellence, academic excellence. Howard's, you probably could find 1 million people in America and not one of them could name any football player who ever played for Howard. I liked that. Lab High did not have a football team, and I always regarded that as a plus, because leadership at my high school was not based on athleticism. I have nothing against athleticism. I do have something against its being touted above and beyond that which lasts longer, and that's academic excellence and the emphasis on learning. So I chose it because of its status as a capstone of learning. I chose it in addition to that because it was in a place that was itself an education. I'm sure that New Haven, Connecticut is a lovely place, but it's lovely chiefly because Yale is there. I can say the same thing, and I'm sure with some objection, about Auburn. But it's lovely because Auburn's there. Washington is not lovely because Howard is there. Without Howard, Washington is still a supremely stimulating environment with innumerable things to do, places to go, stuff to see, horizons to broaden. So where you go to school is as important to me as the institution you choose.
When you went to Howard proved to be as significant as the choice of Howard itself. You were there in those 60s,
yes,
when revolutions abounded. And I suspect that even as a student, you were not oblivious to what was happening in America. How did that impact you?
I entered college approximately 2 years after the March on Washington in 1963. America was abuzz with protest. African American protests, derivative protests by women for rights, and a partially derivative protest against the war in Vietnam. So those three axes were the cornerstones of protests across America in the 1960s. Howard was by no means immune. And protest meant a couple of things. It had what we lawyers call a substantive aspect and a procedural aspect. The substantive aspect was, of course, the cause for the protests, either race, equal rights for women, or anti-war sentiments. The procedural context, however, was the chutzpah or the nerve or the enduring sense of responsibility it gave you to go out there and do something rather than just talk about it. So at Howard, we took over the A building. It was the first time, and the A building at Howard was the administrative building where the president's office was and other administrative offices. So at Howard, students occupied, if you will, the administrative building. I don't know this, but it wouldn't surprise me if Howard's campus was the first campus on which students actually occupied a building. And yes, it was exciting because I was 19, so yes, it was exciting. But it was also meaningful because it was at once a graphic demonstration of and nonviolent demonstration of rejection of thoughtless oversight, which we deemed the Howard administration to have been doing at the time. And number two, an insistence that those who govern should have an acknowledged voice in governance.
To what extent did your exposure growing up in Montgomery during the nascent civil rights movement make you more or less afraid of engaging in those revolutionary protests, which were front and center at Howard?
Oh, growing up in Montgomery was one of the reasons I felt so comfortable doing it. One of the reasons I was willing to undertake the risk as a student, and one of the reasons why I believed in the usefulness of that kind of demonstration. I had seen it work in my own life as a child. The boycott was by every measure a success, and it yielded the results that it intended to yield, namely restructuring of the seating on the bus, but also the most important result of segregation on the bus is unconstitutional, which really was not one of the initial goals of the boycott. So I understood that it could be useful. I understood that it could work, and I also understood that it required unity of purpose, which we had at Howard.
And at Howard, you also were exposed to some of the nation's civil rights leaders who helped to reinforce your engagement in that process. Are there many memorable experiences you have of listening to some of the leaders of the time, whether in college or law school or in the DC area?
Unquestionably. Everybody came through Howard. I happened to have grown up in Montgomery, so I was accustomed to seeing Martin Luther King Jr., but my schoolmates were not. So when Martin Luther King came to speak on campus, and that happened at least 2 or 3 times while I was an undergraduate student, the arena where he was filled to capacity. So he was there. I can't name all of the other people who were there. Whitney Young was there from time to time. And bear in mind, many of the people who came back were themselves alumni of Howard University. So it wasn't unusual for Thurgood Marshall to be on campus. It wasn't unusual for Patricia Roberts Harris, who later became Secretary of
Health,
Education and Welfare. It wasn't unusual to see these people on campus. I remember a couple of my classmates one morning getting up to jog on the track at the football stadium, and lo and behold, Bill Cosby was out there jogging. So it was just a place where everybody came. In the arts, as well as in what we called hardcore academics.
Now, Howard had a law school, in fact, a very historically distinguished law school.
Yes.
When you went to college there.
Yes.
But you didn't go to Howard with the aspiration to be a lawyer.
No, not at all.
What was your career aspiration when you went to Howard?
When I went to Howard, I intended to become, and did become, a speech pathologist.
What was that triggered by any inspiration rooted in Montgomery?
Yes, it was triggered by my aunts. I've previously described them as having been congenitally mentally challenged. One aspect of that mental challenge was their inability to speak adequately. I won't say appropriately, because such high-level things like grammar and syntax were out of the question when it came to them. They just simply had trouble pronouncing words, and it inspired me in a kind of elemental way a desire to become a speech pathologist. So that was my major at Howard all 4 years.
And you graduated cum laude, is that correct?
Yes.
All right. Now, though you were not at the law school, you were clearly exposed to the law school, and it was the site of instruction and learning for your first husband.
Yes.
Tell us how you met him.
Yes.
and a little bit about your decision to get married while still in college.
Well, when I was at Howard, I had a 4-year scholarship as a National Achievement Scholar. So my parents didn't have to concern themselves with tuition and books and all the other expenses associated with college. But they still sent me a measly $20 a month. Now, granted, it was 1965, but $20 a month. So, calling upon Sweet Mama's mantra of being independent, I decided I wasn't going to ask for a penny more Instead, I would find a student job.
And
So
what did you do?
I started working as secretary, the working secretary of the Student Bar Association at the law school. And that is how I met my first husband, Winston Durant.
And where was Winston from?
Winston was from Georgetown, then British Guiana, which later became Guyana. He had attended Virginia Union College in Richmond, Virginia, and later went to Howard Law School. He was 6 years my senior.
And it was love at first sight.
Love at first sight, yes.
You got married at the end of your junior year at Howard?
Yes, at the end of my junior year, Winston and I married. And I finished my last year. I had only a semester to do in my last year because I had picked up extra hours along the way. So I actually completed my college work one semester into my senior year.
And Winston had completed law school when you married?
No, Winston didn't complete law school until a year after we married. Not a year after, yes, a year after we married, because we moved to New York City in September of 1969 after I graduated in May of '69.
Okay, all right, so the move to New York City, was that for the career you had planned for yourself?
Yes.
Or for the career that Winston had planned for himself?
No, actually it was triggered by my admission to Columbia University for graduate school, though it was no secret that Winston wanted to end up in New York.
Right.
I had applied to graduate school while a senior at Howard, and I was admitted to Teachers College at Columbia University. So I went there to pursue a master's degree in speech pathology.
So you were still very much in tune with having a career premised on speech
Very
pathology.
much so.
And grad school was 2 years?
Grad school was 2 years. Well, actually a year and a half.
You got your master's?
Yes, I received my master's degree in, I received the master's degree in May of '71, but I actually completed my work in January.
What was it like relocating from Washington, D.C. to New York City?
It was very different. New York is, if anything, crowded. It is, if anything, expensive. But I loved it because it was New York City. And apartments there tended to be smaller than they were in D.C. It is, after all, an island. And but it was so vibrant, and I enjoyed the vibrancy of New York. Again, New York is an education in and of itself, like Washington. So in addition to pursuing graduate study, I had the opportunity to be exposed to the air of New York City.
The arts included?
The arts included the United Nations atmosphere on every street corner. New York was the first place I'd ever been where it was not common but expected that in a block's walk, you'd hear at least 3 or 4 languages.
When you completed your master's at Columbia, did you get a start with the career you had planned?
Yes, I did.
What did you do?
Yes, I did. I worked from January through August of 1971 for AHRC as a speech therapist, and I was located in one of its school locations. I worked with mentally challenged students who at that time were called mentally retarded students from age 7 to approximately 11 or 12 years old. They were in groups, in classes, just as children would be in public school classes. The children were endearing. The goals were honorable. The work was draining. I decided as time went along that I just wasn't cut out for that kind of work. And I probably made a wise decision given my satisfaction with my legal career that followed, but a premature decision given the fact that that environment is one of many in which speech therapists worked at the time and work today.
So you probably could have worked in another setting and really decided this career in speech pathology is where I want to be?
Yes, that's likely.
Well, how is it that you made the transition so readily? You're working from January to August. You enrolled in the law school at Columbia that next month.
Yes.
Was it your husband's career taking off in law that influenced you to say, I can do this?
That was it in part, but in truth, there were two precipitants to my decision to pursue a career in law. One was my desire to help more than one person at a time. That was part of the drain of working as a speech therapist. I was working with one person at a time. The progress was slow. So that was one trigger, one precipitant. The other one was that I didn't feel as though I was expressing that that aspect of challenging the status quo, which was very much in need of challenging as a speech therapist. And I had no avenue to do that. And I as an individual, wanted to challenge the status quo. I could do that as a lawyer. It was not likely that I would ever be able to do that as a speech therapist.
Was your choice of Columbia to study law a deliberate choice?
Well, it was deliberate in that I applied to only two law schools, Yale and Columbia, the first of which rejected me, leaving me with Columbia that accepted me. So it was a deliberate choice of two. Yes.
Columbia, though, was and remains one of the top 5, top 10 law schools in the country.
Yes.
And was not a shabby choice for you.
No, not at all.
Even when compared with Yale.
It was not. And I can promise you that it is not in a spirit of sour grapes that I say that I have been eternally grateful that I went to Columbia instead of Yale.
What are the roots of that gratitude? Share with us a little about your law school experience.
Aside from from what everybody knows to be the snobbishness of Yale grads, I had a chance to remain in New York. I had an opportunity to have my first child in New York and to taste the city in ways that I hadn't been able to do so 2 years in grad school. So the 6 years that I ended up spending in New York City were just a tremendous growing opportunity for me. And not just growth in what I was exposed to, but growth in thought. One has to learn how to read the New York Times. You don't just pick it up. You have to learn how to read it. And there is no better place to learn how to read it than an hour and a half on the subway going to work and an hour and a half coming back home.
And arguably, there's no better place to learn to love the study of law than at a law school with faculty and students who have a passion for both teaching and learning. Was that your experience at Columbia?
It was, and it was seasoned. That experience was seasoned by the fact that I had at least 3 law professors who wrote the textbooks from which we were learning. That was invigorating, and I had law professors who were actually engaged in the practice, either as actual litigants or litigators rather, or as consultants. I didn't take a class from her, but Ruth Bader Ginsburg was on the faculty at Columbia when I was there. And she had a practicum as well as her seminar at Columbia. Jack Greenberg, the former director counsel of the Legal Defense Fund, was on faculty there. So we had several people who were actually involved in helping to make landmark decisions in the law who were on faculty.
Were you one of those students who reveled in the study of law and being in law school, or dreaded it as just a necessary precursor to becoming a lawyer?
No, I was the strangest animal. I loved law school. I absolutely had the most wonderful time in law school. I liked the study, I liked the reading, I liked the challenging. Analysis had then and still remains a passion of mine. I liked meeting the students and arguing with students. I enjoyed being in law school at a time when real change was being made. I was in law school when Roe versus Wade was decided. I was in law school when the Supreme Court decided that there was a constitutional right to travel. I was in law school when the United States Supreme Court decided that dragnet warrants, the Draper case, dragnet warrants were unconstitutional. So things were happening, and in each of those instances, Columbia faculty played genuine roles in those cases, in the advocacy for those cases. And in my third year, I was pregnant the whole third year, beginning with September and going on until when I graduated. My son was born 2.5 weeks after I graduated. And
still you were a participatory, fully engaged student.
Oh yes, it was easy to do that. I don't know if I had a classmate who was also pregnant. I don't remember. I may well have. But I was the executive director of the Moot Court Executive Committee for all of my third year. So yes, I was a full participant in law school life. I just enjoyed the experience. I just thought that I believed then, as I do now, that real education teaches you to stand firm in defense of your position and to understand and be able to analyze an opposing position, whether or not you're a lawyer.
And did Columbia boost your skills in that regard?
Unquestionably.
Having grown up in a strictly segregated, racially segregated environment, and matriculated at Howard in what was, I'd probably wager, a 95% black environment.
96.
96%.
96, I know that because there was a stat study done when we were there.
I was only guessing.
Mm-hmm.
In the 96% black environment, did you find at Columbia, whether in grad school or law school, any obstacles premised on race discrimination, either in law school or in grad school?
No. No, as a matter of fact, as I have often said to you, my experience at Columbia, both in grad school and law school, led me to believe that the supposed inferiority of African Americans was a hoax. And I have called it a hoax for all of my adult life. It's a hoax. The one difference that is race-based and segregation-based that I found to have been advantageous for white students generally at Columbia is that their parents and grandparents had been afforded opportunities that blacks were deprived of because of race, and those opportunities advanced them from generation to generation. The most concrete example I can give you is that many, not several, many of my law school classmates were children of lawyers. And they had grown up with res judicata and res ipsa loquitur around the dinner table. And they already understood legal jargon. They understood the legal method. I did not understand it when I arrived at Columbia. So the advantage was exposure, not cerebral.
How about your black classmates? What was the racial diversity at Columbia back then, and how large was the law school?
My entering class was 283 students, and 35 of them were black.
Did you find that the black classmates were heirs to the study of the law as you did the white classmates, or were they more in your area in terms of not having had parents or grandparents or other relatives who were lawyers?
They were as I was. I don't remember a single African American classmate who had a parent, mother or father, who was a lawyer. Mm-hmm. Now, most of us had parents who were professionals, but not lawyers.
Now, at Columbia, though, your race did not prove a hindrance in your expanded leadership role in law school. You actually chaired the moot court board during the same time that you were pregnant?
Yes.
Yeah. And you competed, did you? As well?
Oh yes, that was a competitive position. One had to apply for that position. But and it's a big but. One of the more egregious elements of race discrimination is that you are aware when some of it occurs, totally oblivious when the rest of it occurs. So I can't sit here today and say that my race was not a hindrance, because I wasn't privy to those conversations or decisions that may have deprived me of opportunity because of my race. I know there were some, because this is America.
Sure, but based upon what you did observe and the experiences you did have, Columbia for you was a positive experience.
Unquestionably. It was a positive experience. It was, it hastened my professionalism. It was nurturing, and it was affirming for the most part.
And you have nurtured alumni relationships from Columbia Law School.
Yes.
Regularly. I think you've been back to speak to students there.
Yes.
You've been honored and
some
recognized.
years ago, I was the keynote speaker at the Black American Law School Association dinner, which is called the Paul Robeson Dinner, named after Robeson, who attended Columbia Law, who graduated from Columbia Law School in the 1920s. And I have gone back for reunions. I always feel very welcome and nurtured. I enjoy wholesome relationships with my classmates. Frankly, more relationships with my white classmates than I do with my black classmates.
Okay, you get your JD degree in 1974, right after or before delivering birth to your son Reagan. Was that June 8, 74?
June 8th, 74.
Did you graduate before or after delivering birth?
May 15th, 74 was my graduation date.
Let's make that transition now then from law school graduate, parent, wife, to lawyer, and you're still growing out. But the second phase then of your growing out is your practice there in New York. You had to tackle the New York bar and get a job. Had you had jobs during your law school career, as many students do during the summer months?
Yes, of course I did.
What was the nature of your summer law experience as a student?
After my first year of law school, or the summer after my first year of law school, I worked as an intern at Legal Services for the Elderly Poor, located on 7th Avenue. I was an intern. I did elementary research. I'm sure I did filing and some other clerical duties, but it was yet a learning experience. Learning not just in the pedagogy of law, but also becoming sensitive to the fact that elderly people had peculiar legal problems and poor people had peculiar legal problems. The combination of that led me to understand why someone could specialize in that. The summer after my second year, I worked at Thatcher, Prophet and Wood. It was, and I think remains, a law firm then located at 40 Wall Street in Lower Manhattan, under Robert Stitt, a partner at Thatcher Prophet. And that was an amazing learning experience. I spent the summer doing what, you know, any regular old second year law school intern would do, but it was very helpful in learning, for me, in learning how law is really practiced and should be practiced. I was annotating depositions for much of the time, but I was also doing legal research on an elemental level as compared, of course, to the associates. But I gained an understanding of the hierarchy of a litigation team, which doesn't always appear to be obvious to the average person.
Now, by second year or before, had you decided on the nature of your desired immersion in law after law school?
No. The wonderful thing about law, and I learned later med school, is that one does not major. One majors in business school, but there is no major. You just take the classes you have to take, and then you take the classes you want to take and make a decision thereafter.
Now, after graduating in mid-May of '74 and having your child June 8, did you take that summer off to care for your child as you were preparing for the bar?
No.
How did you arrange?
No, and I can't say that doing other than what I did would have made any difference. I was immersed in law, in bar exam study a week after Reagan was born. I studied and studied, clearly not enough, because I took the bar at the end of that July 1974, learned in September that I did not pass. I was at Hughes Hubbard by that time. Alan Hubbard, one of the senior partners at Hughes Hubbard, called me to his office and in the most compassionate, nurturing way, sat me down and told me that I would be all right. I had cried for at least 2 or 3 days, felt like a turtle when I returned to work, swore that everybody was looking at me and pointing and saying, that's the girl who failed the bar. But Alan told me I'd be all right, told me he had failed the first time too, and that he passed the second time. It was the most compassionate thing he could have done. I took it a second time and passed. So in essence, I spent the whole summer studying for a bar that I did not pass. But I went to Hughes Hubbard nevertheless.
Actually, you didn't spend the whole summer. My recollection is that the bar exams were given in July.
Yes.
So you graduate mid-May, you have a child June 8. You really didn't have much time to study for that July bar.
I did not, even though I took a bar exam course. I did not have much time.
New York and California, if I recall, were the states notorious for having the most difficult bar exams.
Yes, unlike Alabama then. I don't know what Alabama does now.
Yeah.
Thankfully, I am just so detached from bar exams. But in New York, you never knew the areas of the questions. They wouldn't tell you.
Right.
You just went in there and you were just alone.
So you went to Hughes Hubbard and Reed. Was it that summer or was it in the fall?
No, it was September.
September. How in the world did you practice law at this rather large Wall Street firm and mother a child and do all those things domestic that you're expected to do?
We managed to secure a Haitian babysitter, Ivris. And Ivris took care of Reagan during the day while Winston and I worked. Winston worked for Atlantic Richfield, whose headquarters was then located in New York City. and I was working at Hughes Hubbard, and so we just managed. It was tough, but we made it.
Was there a time when it became a bit much for you and you had your son transported to Montgomery to live with his grandmother for a while?
Well, he did come to Montgomery, but that was not the reason. The reason he came to Montgomery is because by that time we had decided to leave New York. And rather than try to tie up loose ends and pack and get ready for a major move with Reagan on site, we asked Mother to come up and get him to bring him back to Montgomery to stay while we did that ourselves.
So actually you were separated from your son for barely, what, half a year?
Yes, approximately that.
And during that period, you're working at this Wall Street firm. Tell us about that work. What did you learn? What was the experience like? Did it cement your interest in corporate law?
No, just the opposite.
Just the opposite. Tell
Just
us
the
about
opposite.
that.
Hughes Hubbard taught me so much. It taught me how to practice law. Working there taught me how to keep hours and the value of keeping hours. It taught me the difference between an hour that was billable and one that was not. It taught me the difference between using the library and finding what passed for an answer in the book and applying public policy common sense in addition to what one finds in a book to the resolution of an issue. It taught me how to write memos, how really to write a legal memo. It helped me understand how to be responsible to clients, what the law firm's responsibility to a client was. And when I say how to practice law, these are things you don't learn in law school. Law school is a 3-year adventure in where to find out what you need to learn. So you become an expert in how to learn. One doesn't become an expert in data. You do that in med school. No one is ever going to need a lawyer in 10 minutes. And a lawyer is never going to be able to save a life or do a job in 10 minutes. So you actually learn how to practice by working. And that's what I learned at Hughes Hubbard.
In the scheme of New York Wall Street law firms, was Hughes Hubbard a small, mid-size, or large law firm?
At that time, it was mid-sized to large. When I went to Hughes Hubbard, there were 85 lawyers. It did not, at the time I went, have any office outside of New York. There were maybe 1 or 2 lawyers in Washington. Later, it opened an office in Los Angeles, chiefly because Atlantic Richfield moved to Los Angeles. It's one of its chief clients. So Hughes Hubbard opened an office in Los Angeles. Later, they opened offices overseas in Paris, and I think there's one in Tokyo by now. But it was considered a large law firm.
What was it about that experience at Hughes Hubbard that cemented your resolve not to stay in corporate law and not to be in New York anymore?
Well, to your first point, not to stay in the practice of corporate law, remoteness. You never see your client. You're working for an entity. Yes, that entity from time to time has a face, a human face, but you're not really working for that human face. You're working for an entity. That's one aspect of remoteness. The other aspect of remoteness is that you are not working to improve the quality of a life. There is not a connection to an individual. Wall Street work in the main, I don't say this in criticism of it, but I do say it hopefully in accurate analysis of it. Wall Street work is about money. Who has it, how much, and what are we going to have to do to hold on to it? That's Wall Street work. So I didn't want to spend my life working for clients I seldom saw and essentially working in an environment that was all about securing, securing and retaining money.
Was Alabama always on the horizon
No.
for you? Were there
No.
other options that you and Winston considered?
We knew that we wanted to move south. I don't really remember why we came to that conclusion. I'm sure that in my 28-year-old mind at the time, weather had something to do with it. I'm not sure it would be that dispositive now, but we had only two options in our heads. One was Atlanta, the other was Montgomery. Montgomery chiefly because it was my home, Atlanta chiefly because it was sexy.
Let's make that transition now from New York to Alabama. You're back home in Montgomery, and you are entering the phase of being a lawyer in your hometown, reunited with your child, coming back with the husband whose introduction to Montgomery had been only through the wedding.
Yes.
I assume he had no other roots in Alabama or in Montgomery.
Or in America.
Or in America. Contrast first for me the Montgomery you left in 1965 with the Montgomery you found in 1975 with a view to communities. You certainly have described your growing up communities, governorates, and the extent to which there was still a decidedly black community and a white community. Give us that broad overview of the Montgomery you entered when you came back and said, now it's time for me to practice law here.
You know, I never thought about that before, but thinking about it now, it can be adequately compared to the id, the ego, and the superego. The Montgomery I found had a superego much different from the Montgomery I left. I did not find myself prohibited from doing anything or going anywhere, occupying any spaces, being with any other people in peace. The ego was the super awareness of the past prohibitions, the lingering, let's not do that. For example, when I returned, I never saw interracial couples as I had seen every day in New York and as I see every day now in Montgomery. I did not see African Americans working in some places. Montgomery was just really beginning to have African American bus drivers, African American cabs at the airport. So that ego level, that mid-level, was just beginning to ripen and blossom out. The id hadn't changed one bit, as ids seldom do. There was still the stare. It was very clear to me that there was still an effort to govern and keep African Americans in their place. I happened to have returned to Montgomery in October of 1975. That was just around the time that Act 618 was enacted and Montgomery became a mayor-council. Montgomery's government became a mayor-council form of government. 4 blacks were elected, 5 whites were elected. All of the votes almost were racially split. So that id was there.
And prior to that time, there had been no blacks in any level of governance in Montgomery.
Prior to the mayor-council form of government in 75, there had been none. Mm-hmm. And obviously the change was not going to be immediate. And the id was kept in place largely by the identity of Montgomery's mayor at the time. Mm-hmm. Jim Robinson was the mayor. There was a significant police incident that occurred during his mayoralty, the Whitehurst case. And when he stepped down, the president pro tem of the city council, Emery Falmer, became mayor.
And he was mayor for most of your law practice. We'll get back to him.
All of it.
In a second. So that's a major contrast in governance. What did you find in this Montgomery you returned to? What did you find about living in Montgomery? You'd left Montgomery with neighborhoods pretty much defined by race.
Yes.
Blacks lived on the west side or near Alabama State. Whites lived elsewhere. Did you find that divide still existing, and what choices did you and Winston make about where you would live?
Well, interestingly enough, Winston and I asked my parents to find us a house. And we may be one of only or a few of our friends who ever had parents find a house sight unseen and move into it. That's exactly what we did. Yes, I knew that Mother and Daddy shared my values. They knew what I wanted. I gave them restrictions: no corner house, no two-story house. I knew I wanted a one-story house in the middle of a block, and I didn't know Montgomery's neighborhoods well enough to make any designation because I hadn't lived in Montgomery for 10 whole years. So I entrusted them with finding us a house, and the one they found has been an everlasting pleasure for me. I'm still there. I live in Heart Estates. I live on the west side. I live in a neighborhood that is now totally African American. It was not at the time I moved into it. So to answer your question, I found that the neighborhoods were still racially defined, but not necessarily racially restricted.
When you left, of course, the schools were, in 1965, the public schools were only beginning the process of desegregation.
Yes.
When you returned in 1975, what did you find in terms of public school integration and its impact on housing and residences in Montgomery?
Well, by that time, African Americans had begun to move to other parts of the city. And by that time, apartment complexes were much more common in Montgomery than they had been when I left. When I was a child, an apartment meant the projects. When I returned, apartments were much more the product of private commercial development. So African Americans were pretty much all over the city. Mm-hmm. But as I said, neighborhoods were still principally racially defined.
And did you also discover in 1975 that there had been considerable abandonment by whites of the public school system?
No question.
A concomitant abandonment of neighborhoods that had once been occupied by only whites?
Well, there were a number of factors that occurred. Some of them we talk about a lot, like white flight from neighborhoods, which in essence is what occurred in Heart Estates. When I moved in Heart Estates, I dare say the black-white ratio was no more than 30-70. 70% of my neighborhood was occupied by whites when I moved there. Gradually, they moved out. So, yes, and by then, the segregation academies that I mentioned before had been in existence for 20 years. Mm-hmm. So they were well developed into recruiting white students. So yes, I found that, but there are other underlying or undercurrent factors that contributed to that. Racial desegregation of public schools was as hypocritical as any other aspect of desegregation. My father, as I mentioned, was a high school principal. One of the most heinous moves that white superintendents and boards of education all across the South, and especially in Alabama, took was to make the assumption that integration meant that black people had to relinquish or abandon or forfeit their schools in favor of schools that were predominantly white. Integration, in essence, was a one-way street. It still is largely a one-way street. One concrete aspect of that is that black high schools all over Alabama were closed or made junior high schools. So my father's school, Prentice High School, he had left there by then, but my father's school, Prentice High School, was turned into a junior high school. My father's colleagues, black high school principals all over Alabama, who had been principals of high schools, all of a sudden found themselves principals of junior high schools. I don't need to tell anybody what that does to reduce your status, and in some cases your pay. What it does to reduce opportunity for leadership and management and control of operations, and the opportunity to mentor students through their senior years. So I have always considered that to have been one heinous aspect of desegregation.
Another heinous aspect that I'm sure you could relate to, if for no other reason because of your mother's experience, is the expectation or requirement that the best of black teachers be the ones to go to the schools that were still predominantly white, while it really did not matter about the quality of the teachers sent to the schools which were formerly black. Do you recall that phenomenon as well?
That continues to today. That continues to today, if people were honest. Yes, assessments were made early on that those black teachers regarded as really good teachers were sent to schools that were predominantly white.
Wasn't your mother in that category?
Mother was in that category. And as I said, black teachers and white teachers who were deemed not so good after integration were sent to schools predominantly black. Even today in Montgomery, it is considered a penalty for certain teachers, for teachers to be sent to certain schools in Montgomery.
Now, what happened to all those wonderful master's degreed, college trained, or college experienced teachers from your beloved Laboratory High School? Was it still here when you came back in '75?
No. Levi Watkins was president of Alabama State University at the time. Lab High closed in 1969. It became defunct as a high school. The building remained, but the school closed.
4 years after your graduation?
Yes. The last graduating class was May of 1969. Lab High students were not integrating. They weren't going anywhere. A few of them left. I think you went to school with 3 or 4 of them. But for the most part, black students at Lab High weren't going anywhere. They weren't going anywhere because they didn't need to. They weren't going anywhere because they didn't want to. Had I been there after '65, I wouldn't have gone anywhere either. We were getting a very good education. We enjoyed where we were. We did not feel deprived. We weren't deprived, so why move? So they weren't going anywhere. And I think the superintendent then must have been Silas Garrett.
The superintendent of education?
In Montgomery.
Mm-hmm.
I could be incorrect, but I believe it was Silas Garrett. The superintendent and the board decided that they needed to have the students at Lab High integrate into white schools. It's wholly unnecessary.
How were they able to do that when the laboratory school was essentially a private tuition-funded school?
Well, because it wasn't completely tuition-funded. Like any school, it's only partially tuition-funded, and in general, and in the case of Lab High, tuition was the lesser source of revenue. It happened that the Board of Education was using some of its money to pay for students, to pay for Lab High. Just as the Board of Education, any Board of Education today uses money to pay for charter students, because in Alabama, going to school until age 16 is a mandate. It's a legal mandate. So as long as you're required to do it, the government has to subsidize your doing it. So in that spirit, as with charter schools, the Board of Education for Montgomery County was also subsidizing Lab High because kids went to school. And ASU was kicking in some amount, and the tuition was kicking in some amount, but by no means did the tuition furnish even the larger part of the cost of operating the school. So the Board of Education had a stake, if you will, a financial stake. And together with Dr. Watkins, who was president of ASU at the time, and the governor.
Was that George Wallace then?
I don't remember whether it was Wallace or Patterson.
No,
I don't remember.
I'm remembering it.
It was
68,
Wallace.
69, that would have been George Wallace.
Wallace, yes. So together with Watkins and Wallace, they all made the decision that the way to get the Lab High kids into the white schools was to shut it down. So that's what they did.
What happened to those teachers?
They were scattered across the spectrum of public schools in Montgomery. Several of them went to Lanier, a few went to Lee, and I'm sure others went elsewhere.
Your mother was among those who went from the laboratory school to Lee?
Yes. Mm-hmm. And by all measure that I heard, they were all miserable.
Now there was one other change in Montgomery that was rather drastic. I want you to talk about when you left here in '65. You described a community on the west side, on your Chappelle Street neighborhood, or in your Chappelle Street neighborhood, and basically all the blacks who lived south of Court. A community that was institutionally stable, self-contained, as far as business structures, professional outlets, the institutions that service the community. By the time you returned in 1975, that community had been rather decimated by the interstate highway. Comment on that, if you would, and how that altered the trajectory for this city that is our home.
When I was growing up, I could go along Jeff Davis Avenue in West Montgomery, intersected by Holt Street in West Montgomery. And between those two streets, I could go to a grocery store, go to a dentist, a doctor, go to a shoe shop, a barber shop, fill my car with gasoline. I could go to a movie. I could buy clothing. And if I died, I could go to a funeral home or have myself taken to a funeral home. Such was the concentration of black businesses along that commercial pathway in West Montgomery when I was growing up. In Montgomery, as well as other cities, it has now been confirmed that white government leaders in the city made a deliberate decision to route interstates through the heart of black business communities. You can see it in Birmingham, you can see it in Montgomery. I am told that you can also see it in cities north of Alabama along Interstate 65. If you travel on 85 going through Atlanta, you can see it when you go through Atlanta. It is no accident that the confluence of 85 and 65 in Montgomery are located in the very heart of the African American business community. It destroyed the community. It is no more, and it destroyed it permanently. Now, it isn't that those businesses didn't relocate, but just as businesses are finding it now with the pandemic, once you are shut down by exigent circumstances, it's either very difficult or impossible to relocate with the same success.
And in many ways, would you agree, the black business and professional community never recovered that swagger or that chutzpah that it had during your growing up years?
And in some cases, that existence. Shaw's Bakery is an example. It was a thriving bakery along Jeff Davis Avenue when I grew up. After the interstate, there was no Shaw's Bakery.
There were, what happened to the hospital that you were born in, Oak Street General?
It went out of business.
And there were adult schools that were owned and
Lowe's
designed?
Adult School was on Jeff Davis, designed principally for people who had not graduated from high school, and it too went out of business and was not able to reopen. The financial burden and the capital requirements of reopening, which included in their cases rebuilding or renting space, was so dire that it was just impossible. And we won't even, and that's the commercial side. I can name 3 churches that had the same fate. One among them was First CME Church, a grandiose, majestic building. Metropolitan, United Methodist Church, another grand building, just evaporated. As a result of the location of the interstate highway, and that interstate highway could have been located anywhere they chose to.
So it's against that environmental backdrop that you come back to practice law, and of course, the first step always is taking and passing the bar exam before you can find a decent job. You managed that very well in 1975. Is that right?
I did. Now, Reggie even allowed me to type my exam.
Reggie, as in Reginald Hamner, who was then the executive director of the state bar.
Yes.
Is that correct? Now, let's, before we get you working as a lawyer and talk about those experiences, it's important for us to underscore the history of black lawyers in this state. During your growing up years here in Montgomery, what black lawyers were you aware of?
I knew 3 black lawyers when I was growing up. I knew Fred Gray, obviously because of his involvement in the Montgomery bus boycott, but Fred and Bernice Gray were also members of Tots and Teens, and which is a black social organization designed especially to provide recreational and other educational activities for children. Fred's children were members of Tots and Teens, so I knew him. And my mother and Fred knew each other growing up. They were born not far. They grew up not far away from each other.
So the venerable Fred Gray was...
I knew Solomon C., and I knew I knew Calvin Pryor.
You did not know Charles Langford?
I did not know Charles Langford, and I really did not know Charles Conley.
So actually, you've now named all the black lawyers who were lawyers during our growing up years.
Yes.
Fred Gray and Charles Langford and Solomon C., who were once all partners. Then there was Charles Conley and Calvin Pryor.
Yes.
Now, when you came back in 1975 and passed that bar exam, what was the black bar like in Montgomery? What did you find?
By the time I returned in 75, it was in its nascent period of growth. And it was in its nascent second generation. Although Gray, Langford, Say, Conley, and Pryor were not the first black lawyers to live and practice in Montgomery, as a group, they still comprised the first generation. The second generation was my generation. So when I returned, the second generation had begun with Charles Price and Myron Thompson and Billy Carter.
And to be clear, the second generation would be those lawyers who were graduating law school in the 70s.
Yes.
And beyond, while the first generation of Gray and C and the Langford and Pryor typically graduated law school in the 50s.
Exactly.
And endured most of them, if not all, that we've named, having to go outside the state of Alabama to go to law school, because the state's law school, its flagship law school at the University of Alabama, would not desegregate. Is that right? Is that your memory?
Yes.
All of them. You came back as part of the generation, the second generation, that had a choice, I believe. By then, the University of Alabama had desegregated its law school.
Yes.
So that you probably came back around the time that some of the law students, the black law students from the University of Alabama, were also settling in Montgomery. But I think you also came back with probably more quantitatively lawyers who'd gone away from Alabama to law school. You mentioned Myron Thompson, Judge Myron Thompson, an esteemed judge on this court, and you mentioned Charles Price, himself an esteemed judge at the state level. Both of them had gone to law school outside the state. Is that your memory?
Correct.
Okay. So you came back and found the same lawyers you left, in that
yes,
I think,
I did.
if I recall, all of them were still here.
Certainly.
And you ushered in a new generation of lawyers.
Yes.
How did you find work after getting that bar exam behind you?
I already had work prior to the bar exam, as I recall. Again, Mother and Daddy became not just housing agents, but professional agents as well. My mother knew Judge Richard Emmett very well. Judge Emmett was at the time the presiding judge of the Montgomery County Circuit Court. And she implored him to help her find her children work, because they wanted to come home, and there was nothing Mother wanted more than to have her children come and her grandson live in Montgomery. So she prevailed upon him. He prevailed upon his friend Walter Turner, who was then Chief Deputy Attorney General, serving under Bill Baxley, who had been elected to office as Attorney General for the state of Alabama in 1974. And Winston and I applied for work in the Attorney General's office. We were hired, and that is how we began when we returned to Montgomery.
So you start your career as a lawyer for the state of Alabama. You are an assistant attorney general.
Actually, I was an assistant. Actually, I was a legal intern. Both of us were, until I received notice in September that I had passed the bar. Then I became an assistant attorney general.
And did you find at the state attorney general's office a welcome mat?
Very much so. Everyone was welcoming. Yes, I did. And when I say everyone, I mean all the staff. Now, there was a bit of eye rolling and perhaps hesitance to receive me by some of the clerical staff. The clerical staff consisting mainly of women. I was the first black woman to work in the Attorney General's office, and receiving women as administrative superiors is a different animal from women receiving men.
That could be a separate interview in and of itself.
Yes, absolutely.
But
among my colleagues, namely the lawyers, male and female, most welcoming.
You and Winston certainly weren't the only black lawyers there at the Attorney General's office.
No.
Between 75 and 78. I
No.
dare say that the bulk of the black lawyers in your second generation had their immersion into Alabama law practice under Bill Baxley's office.
Very, very much so. Baxley was and remains intent upon diversifying government and workplaces, and he had an almost penchant for hiring Native Alabamians who wanted to come home and get a start, and the Attorney General's office was a very good place to start. Among those who were with me in the Attorney General's office were Jock Smith, Milton Davis, Aubrey Ford.
Was Milton Belcher
Milton
there?
Belcher, he was the next one I was going to name. Karen Neal Knight.
Wasn't Judge Thompson there for a while when you were there as well? Or
No, our
left?
terms never overlapped. Judge Thompson was the first African American hired in the Attorney General's office in 1972 when he graduated from Yale. But he had left by the time I arrived.
And had Judge Price left as well?
Judge Price had as well. Judge Price came in 1973. Winston and I came in 1975.
So from the Wall Street drudgery of writing memos and annotating depositions, you land in an Alabama Attorney General's office in 1975 when I suspect there was a little more action to be had.
There was, and I don't necessarily take issue with your use of the term drudgery, but I don't want to give the impression that working at Hughes Hubbard was a downer, because it was an upper in so many ways. And I have to say that it was clear that the work was monumental. It just wasn't my taste. For example, the most exciting thing I did at Hughes Hubbard was to do a memo when I worked under Philip Lacavara, who was a partner in Washington. And I actually did a memo, a long memo, on Puerto Rico's potential as a state. That was a very exciting thing to do. It still is, because obviously it still is not a state. But the issue has been going on for so long, so it was very exciting. But to get back to your question of coming home, yes, the access to justice for a client was more immediate. I was working for the state of Alabama. I was actually going to court. Obviously, the Attorney General's office is an appellate legal theater, and therefore we were handling appeals on behalf of the state filed by defendants who had already been convicted. So I had the opportunity to argue before the Court of Criminal Appeals and the Alabama Supreme Court.
And you did that fairly regularly, didn't you?
Quite regularly.
I happen to have heard some lawyers who were then employed at the Attorney General's office, who thereafter became judges, at least two on the federal level, comment on how it was widely circulated when Vanzetta Penn Durant had an appellate argument and she'd draw an audience.
I don't believe them.
You don't believe that, but you know you've been told that.
Yes,
and you've been told
at least two
of
them have said it to me. It was an exciting arena to be in, because the 7 judges on the Alabama Supreme Court were venerable.
Yes.
They were venerable, and they were venerable lawyers before they became judges.
And weren't these the same judges who finally put Alabama's state judiciary in a wonderfully bright light in terms of national politics and national jurists?
Yes. When Alabama
Name some of them, just for the history of it.
Of course, the one who predominates is Howell Heflin.
Yeah.
Senator Howell Heflin, who ultimately became a senator in 1978. But Howell Heflin was chief judge of the Alabama chief. Do we call them judges or justices? Justice of the Alabama Supreme Court when I came, and so I had 3 years access to Howell Heflin. James Bloodworth was on the court. Eric Embry was on the court. Renault Allman was on the court. Janie Shores was on the court. Richard, is his name Richard Jones? Well, anyway, he was on the court. Justice Jones
was definitely
on the court. Hugh Maddox was on the court.
Needless to say, it was a time when Alabama lawyers modeled themselves after the justices on our appellate courts, including our high courts?
Oh, in stature, and I'm talking now about levels of status, but in stature, in reputation, in regard, in public regard, and in professional regard among lawyers, the Alabama Supreme Court in 1975 was comparable to the U.S. Supreme Court. For the reason I just named, but as well because notwithstanding the requirement that one be elected to our Alabama Supreme Court, it was not a political court. And the members of the court were not politicians. They were to the extent they had to get elected, but the overwhelming perception was that their decisions were based first and most importantly on solid analysis of what the law required. And sadly, that's gone.
So making arguments before the court was clearly a substantive part of your work at the Attorney General's
Very much
office
so.
that you enjoyed.
And the most challenging part, because they were not easy.
Now, there was another substantive component to your work as an Assistant Attorney General, a principal component. What was that? Was that your work as in child support?
Yes. In 1976, Congress, I don't know whether it was enacted, I think it was enacted in 75, but in 1976, Congress actualized the Child Support Enforcement Act. The Child Support Enforcement Act permitted states to pursue, on behalf of the state, persons who did not pay child support, and to pursue the setting of child support. Theretofore, it was a private matter in domestic court. As of 1976, the state's district attorneys could pursue child support on behalf of the state on the theory, the accurate theory, that if the man, and usually it was a man, did not pay support, the state stepped in to support children. So it was a moral issue of supporting the child support obligation of the absent parent, but it was also designed to save the state the money and to recoup money the state had already paid. And Bill Baxley asked me if I were interested in being the Attorney General's rep in that regard, and I've jumped at the chance.
And what did that have you doing? Did
Well,
you travel
it
around
had
the
me,
state?
I was in charge of all the child support enforcement from a prosecutorial standpoint in Chilton and Autauga counties. So twice a week, I traveled to Autauga and Chilton counties and prosecuted child support cases against absent parents, chiefly fathers.
And was part of that process having adjudications of paternity?
Yes, unquestionably, because paternity was often challenged.
I suspect you were not a popular person in those courthouses when you showed up.
Not really. Popular among mothers, but and in some cases not even the mothers. But no, you're right, not really popular.
How did that experience shape you, if at all?
That experience helped me understand the depth of the problem of absent fathers. I really began to, because I didn't grow up in an environment of absent fathers. And so that experience helped me understand how deep it was and how harmful it was to children. It also helped me understand how important it is for lawyers to be sure that the ends they pursue have a practical outcome. You're not just in pursuit of some legal outcome or proof or actualization of some legal theory. It ought to be practical. It ought to mean something to somebody. But sadly, it also helped me to understand how woefully uninformed and indeed ignorant some women are in their attempts to rear their children. And therefore, how behind some children are from the very day they are born.
What do you mean by that? Uninformed and child rearing.
Well, remember that this is 1975, and I did this until I left in 78. Perhaps it would be less true today with social media and cable TV and smartphones. But in those days, without any of those things, the only access to data and information that people had, were television, newspapers, radio, and magazines. And what do those things require you to do? First and foremost, you have to read. You have to be able to read. Second, you have to be able to listen with understanding, which includes vocabulary. And if you aren't doing any of those things, you're uninformed. You don't have the data. And without that, those mothers were ill-equipped to teach their children anything because they themselves had such little data to work from. They were victims of poor education. There were just things they didn't know. One of the things they didn't know was the reproductive process. I always say that the one good thing about studying communism is that if you're going to hate something, you need to understand it. And these women could not explain to you how they became pregnant. They just simply couldn't. They knew that they had engaged in an act with a man, but beyond that, everything was off the table.
I'm recalling your statement when we concluded the section on your growing up years.
Yes.
That part of your grounding in morality was a resolve that you shared with most girls your age growing up, not to get pregnant out of wedlock.
Yes.
And I'm wondering, as you were talking about your 3-year experience or 2-year experience prosecuting these child support cases, if you regrettably found a number of teenage mothers whose trek toward adulthood had not been as well grounded, so that when you're talking about these uninformed mothers, you're not necessarily talking about adult mothers, you're talking about teenage mothers.
I'm including adult mothers, but mainly I'm talking about teen mothers, and teen mothers of more than one child.
Did you see that as a big change in Montgomery in the 10-year span?
Yes. Yes.
Of your having left and returned?
I did. By that time, we were in the nascent Murphy Brown generation.
For those who don't recall, Murphy Brown.
Murphy Brown, the television character portrayed by Candice Bergen, who is credited with having glorified out-of-wedlock births by having a child out of wedlock in a TV show, an imaginary child in a TV show. And celebrity worship was beginning to reach all-time heights in America at the time. When I was a child, I loved Barbara McNair and Diane Carroll, but I never thought I could be Diane Carroll. By the time I returned to Montgomery, celebrity worship was such, and technology supported that reality, was such that people not only worshiped celebrities, they actually thought they could be those celebrities, so they patterned their lives after them. And one of the ways they did so was, it's no big deal to have a child out of wedlock. No, exactly. So they proceeded to do that. So out-of-wedlock's births in our communities just blossomed in the 70s and 80s and 90s. Only recently has it begun to subside.
Did you by chance find any way to model a different behavior for either the mothers or the fathers, the putative fathers you were confronting during your child support practice as an assistant attorney general? And I guess to be more specific, I wonder to what extent you were able to suggest alternate lifestyles or methods, or go beyond just being a lawyer
Oh, yes.
and being instead a black parent,
Yes.
hearkening them to a different way in a different time?
With the women and the young women who essentially were girls, many of them were 18 and 19 specifically. And I can't tell you, I wish I could do had done a quality control study, but I can't tell you to what extent it was successful. But as a lawyer, I could say things to these girls that the social workers who work for then the Department of Pensions and Security, now the Department of Human Resources, couldn't say. There was some federal restriction or state restriction on their ability to say things. But I could, as a lawyer, say things to these girls. I could admonish them. And the social workers didn't think they could or should. But I could admonish them. I could explain to them the reproductive process. I could explain to them what birth control pills actually did. They didn't know. They had no idea how birth control pills work. They would take them. And some thought that when you didn't take one, you could take two the next day, and that it would work. I mean, that's how woeful their understanding of those processes were. As I often used to say, that when I was doing child support enforcement, and the same thing's probably true now, because America has been so repressive in failing to teach sex education in schools, that we know more about our cars than we know about our bodies. So yes, in some sense, in counseling the girls, I think I did. But here's another way I tried to counsel them. When I was doing child support in the 70s, one child would get you $63 a month in welfare. Two children would get you $118. I actually sat the girls down and asked them to figure out how much more they were spending when a second child was born. And by the time they calculated it, of course, it was 2 times 118, which is what they were getting for 2 children. And I did that for 2 reasons. One, to help them understand that you really don't advance your situation by having another child. But second, to help them ward off the common perception that girls were having babies to get more welfare. Nobody was having babies to get more welfare. In many cases, and really I'll go out on a limb and say most, they were having children because they didn't know how not to.
Well, it sounds like you were clearly making a difference in this first foray into practicing law back in your hometown. You were sharpening your appellate advocacy skills. You were finding ways to get the attention of mothers and would-be fathers in your child support enforcement practice. Yet, after 3 years, you decide to leave. Was that part of your planning, or?
Yes.
All right.
That was absolutely part of the plan.
Why do you say that so readily?
Well, at the time, Winston and I had dreamed of having a law practice together as husband and wife. And we agreed that I would be the first to leave and start a practice. I had no intentions of staying in the Attorney General's office a long time. It just wasn't something I wanted to do for a long time, though I benefited from being there. So in May 19th to be exact, of 1978, I opened my own law practice in downtown Montgomery.
You more accurately had the audacity to open your first practice solo in what was then the most esteemed building in downtown Montgomery, One Court Square. You do recall that?
I do. I recall that.
And I do believe there was maybe another law firm in that building.
There were 2 others.
2 others?
Yes.
Alvin Presswood's firm was somewhere there.
And Kaufman Rothfeder was on the 3rd floor.
Kaufman Rothfeder, and there and blazing on a door on what floor were you? The second floor?
Across from Alvin Presswood. Vanzetta, Penn, Durant, attorney at law.
notwithstanding the attorney at law singular, I suspect there were some who thought you were some kind of law firm.
There were some who thought I was some kind of law firm. Two lawyers at Capel Howard later told me that when they first saw the sign, or the shingle as we call it, they asked, who are they? Who are Vanzetta, Penn, and Durant? Not realizing that it was one person.
And not realizing that it was an audacious black woman in practice by herself.
Yes.
Truly and you stayed in practice in one court square for a couple of years. Was that May of '78 until 1980?
Until 1980, yes.
How did you sustain yourself in solo practice for those 2 years?
Fortunately for me, when I left the Attorney General's office, there was no replacement to do the child support enforcement. So I entered into a contract with the state of Alabama to continue doing that on behalf of the state in Autauga and Chilton counties. And I also attracted individual clients. I was, after all, born in Montgomery. I knew lots of people knew me, and they graciously retained me as their lawyer in individual cases.
Did you find that satisfying?
Very much so. Again, in direct opposition to Hughes Hubbard, I talked to the client. I looked at the client. I knew who the client was. I knew where the client lived. I understood something about the client's life and desired outcomes that helped me to fashion outcomes that were both justifiable and useful to that client.
And by the same token, I must have you comment on how your clients, particularly those who'd witnessed you growing up in Montgomery, felt being able to come to you as their lawyer.
Well, there were a number of clients I had who had known me all my life. And some of them, quite frankly, had difficulty adjusting to the fact that I was now an adult. But they were by and large respectful. But something else that they were, and this emotion, I should say, predominated. They were proud.
Yes.
They were proud of the opportunity to come to a lawyer whom they knew. They were proud of the opportunity to come to a black lawyer. And they were proud of believing that they would be successful. Now, I'm not going to sit here and try to tell anybody that I won all of my cases, because I didn't. But I think the experience of being represented by a black lawyer was different and new, especially the women.
And let me have you underscore the still paltry number of black lawyers, women or male, who in May of 1978 were actually practicing law privately.
It was a paltry sum. There was one other black woman who always told me that I wasn't a real lawyer until I entered private practice.
Someone had the audacity to challenge your credentials as a real lawyer?
Throughout my tenure at the Attorney General's office, and I finally proved myself to her in 1978, and have continued to prove myself to her to the extent that she now lowers herself to interview me.
I was hoping she would remain nameless, but needless to say, there were very few black women lawyers in the private practice in 1978 in Montgomery.
Few. I left most of my colleagues in the Attorney General's office.
Still in the Attorney General's office. After your start in an already built wonderful building that was in the heart of downtown Montgomery, you made a change sometimes in 1980 and went to another area of town to continue your solo practice, the Cottage Hill Historic District.
Yes.
And you undertook there to restore what had been a home to a law office, and did such a good job that the American Bar Association honored you with an Adaptive Restoration Award and featured your law practice and how you had redesigned it. That in and of itself is an achievement that should not be overlooked, but how in the world did you have the audacity to go over to what was either the oldest neighborhood or the second oldest? I forgot which came first. Was it
I think it was the
Capitol
second
Hill?
oldest.
That's the oldest in Montgomery?
I think Cloverdale is.
Okay. Well, Cottage Hill, which is actually bordering this federal courthouse, was quite an old neighborhood. Describe it for us and describe the challenges of building your office or redesigning your office when you did in 1980.
I love old houses. I think there is not one among us who does not have a private alternative profession. My private alternative profession is interior design. I could never make a dime doing it, but I love it. I love designing and decorating interior spaces. So when I decided that I would no longer wanted to pay rent for my office and wanted to own my own office, I went looking. And it was right around the time when the federal government was beginning to emphasize historical preservation in a big way by putting money behind it. In response, Montgomery developed the Lower Commerce Street Historical Development Authority, which was a corporation of a type that lent money to people who were interested in restoring houses or buildings of a certain age. The law office I bought for the paltry sum of $20,000 was in shambles. It had to be completely renovated. And so I borrowed money through the Lower Commerce Street Historical Development Authority and bought the building and renovated it into a law office. There was not much to do on the interior except to fix things.
Mm-hmm. How long did that process take?
It took approximately 4 months, and they were 4 months of a lot of labor and 4 months that quite frankly ended in a lot of sadness. I moved into my law office into the building in late October, 2 weeks after my father died, on October 14th.
In 1980.
Of 1980.
Mm-hmm.
Yes.
Nonetheless, this was an office that your mother and your family and others grew to have an affinity for themselves.
No question.
Because this was the base for what can only be described as your civil rights law practice.
Yes.
This is when you became more than just a lawyer prosecuting child support and paternity cases. By then, I think you left that behind you when you closed your solo practice on One Court Square, or shortly thereafter?
Well, 2 years later, the district attorney for the 19th Circuit, which included Autauga and Chilton County, 2 years later, Glenn Curley, who was district attorney, decided that I was not sufficiently politically supportive, and he decided to take steps to end my contract. It didn't take much persuasion because the Attorney General at the time was Charles Graddick.
Who was not one of your
no, he was not a fan.
Biggest supporters.
No.
All right. So with that cushion removed from you, you set out to hone and narrow your practice. You were still doing family law matters with divorce.
Yes.
In the circuit court.
Yes.
But would it be fair to say this period of your solo practice when you were in Cottage Hill for about a dozen years would be the period which saw you become a federal court litigator?
Yes. I began handling, I had already handled some federal litigation when I was at One Court Square, but I really began to focus on it when I moved to Cottage Hill. Chiefly employment discrimination, and in those early days, police brutality.
And your police brutality practice was aided in no small part by the governance that we had in the city and the county at that time.
Yes.
Talk to us about how many of your cases triggered from action or inaction by those in governing authorities within the city and county of Montgomery.
Well, I'll begin by saying that during my practice, I handled 3 class actions as sole counsel, 2 of which were against the city of Montgomery. I also handled race discrimination in employment cases against the city of Montgomery, and some employment discrimination cases based on race against private businesses in Montgomery. As far as the circumstances that generated those cases, Emory Falmer was like honey for the bears during his reign, and I use the word reign deliberately because Falmer was not just a practitioner of dogma when it came to management of people. He was deliberate, and he seemed to have planned it, and so cases against him in discrimination in employment were predictable. One could almost set one's watch by what he might do or not do.
And he actually, you refer to his reign, you referred earlier to him having assumed the mayoralty after Jim Robinson.
Yes.
And during the entirety of your solo practice, he was still the mayor.
Emory Falmer was mayor from 1978 until he was defeated in the 1999 election.
All right. As predictable as his actions were, there hadn't been a number of lawyers since you returned to Alabama in '75 willing to take him on in court. Would that be fair?
Well, I'm hesitant to say whether they were willing or not. I know they didn't.
All right. So you had 3 class actions when you were the only lawyer involved, involving him. I know that at least 2 of them involved the police department.
Yes.
You had First Amendment claims asserted for
that was the class action.
Some white officers.
Yes,
right?
the First Amendment claim that I prosecuted was on behalf of Steve Island, who did something as monumentally depraved as writing a poem. He wrote a poem about the mayor, and the police officers, by the way, found him unduly intrusive in police operations. But
found the mayor,
yes, unduly intrusive. But they were, of course, afraid to speak up. Steve wrote a poem.
And the poem was not complimentary.
No, the poem was not complimentary.
And for his good penmanship and oratory.
Well, actually, he typed it. And the police department used its considerable skill in investigating and identified the typewriter from which the poem was penned or written. And interestingly enough, it was in those days when the typewriter ribbon was red at the top and black at the bottom.
Yes, I do remember.
And that typewriter, all typewriters had profiles. You know that certain keys typed darker than others, something that you wouldn't even think of today. And so they were able, by looking at the typewriter keys and the type, to identify the typewriter.
And for his good poetry, he was demoted, triggering your First Amendment
the lawsuit. Yes, against the mayor. He was demoted by the mayor, triggering the lawsuit based on his violations of his First Amendment right, which I prosecuted along with Julian McPhillips in district court. We lost the case, and I appealed the case to, by then, was it 11th Circuit? Yes, by the time we appealed it. The 11th Circuit having been established in 1981. And we prevailed in the 11th Circuit, and there were no further appeals.
And in addition to that First Amendment claim, I recall that you had other constitutional claims.
Yes, there was a class action First
conduct.
Amendment claim on behalf of a class of police officers who were retaliated against by the mayor for expressing themselves in ways unfavorable to the mayor. I had two named plaintiffs, David Green and Jerry Hankins, who were officers in the police department. And
white officers, were they?
White officers. And of course the majority of the class consisted of white officers.
Now, the mayor's action or inaction was evident in another case I don't think you handled alone, but you alluded to police brutality cases. And for anyone growing up in Montgomery or being in Montgomery during the 80s, the words Todd Road trigger memories that are not pleasant at all. You were part of a cadre of black lawyers, may have been some white lawyers as well, involved in probably the most infamous, second to the Whitehurst case involving Jim Robinson, the most infamous case of, we'll loosely call it police brutality, that visited Montgomery during your solo practice. Tell us what Todd Road was all about, because this is a case that has triggered quite a few periodicals, may have even triggered a book, if I'm recalling correctly.
A small book, yes.
And you were part of that defense team. Talk a little bit about Todd Road and what that phenomenon meant for Montgomery's leadership thereafter.
Early in 1983, the matriarch of the Taylor family that lived on Todd Road in Madison Park, North Montgomery, passed away. Her sons lived in Ohio and Detroit. They came home for their mother's funeral. Her sons two of her sons in Ohio and Detroit worked for the auto industry, so they had nice cars. They drove back to Montgomery. On the evening of February 6, 1983, they gathered at their parents' house for reminiscing the way that people do when people pass away. Two police officers, I should remember both their names, Jerry Spivey, and I don't remember the other officer's name, were patrolling. They were not patrol officers, they were detectives in plain clothes. They saw the cars, assumed that some nefarious activity was occurring inside the house. They noted that the cars had out-of-state license plates. I don't know specifically what they assumed. It emerged during the case that it may have been some drug activity. They got out of the car. Right at the time they got out of their cars, Christopher Taylor, a grandson of the woman who died, came out of the house to go to one of the cars to retrieve something he'd left there. As he approached the car, they told him to stop. He did not know who they were or what they were. They didn't identify themselves as police. He began running back toward the house, afraid. They drew their guns and shot him in the finger. He got inside the house without further injury. They continued to the house, and without announcing themselves or having any scintilla of probable cause to enter the house, not knowing or suspecting who was in the house, they rushed into the house. The family pummeled them, quite frankly. One of
They
them
assaulted them.
assaulted them. The family, and there were several men in the house. They assaulted them. They beat one of the officers. He secured substantial injuries. They shot another officer because they began shooting, and then the Taylor people began shooting. And the officer somehow got out of the house. By then they had called for backup. Backup came, police officers that is, and there was a cross shooting that took place. It ended with the Taylor family men being apprehended and taken to jail. One of them, who was from Ohio, was beaten badly, very badly, when he was taken to jail. There ensued the Todd Road incident.
And the Todd Road trial, not surprisingly, pitted the police department against the so-called assaulters.
Yes,
and
the vicious criminals who defended themselves.
And I believe you may have been the only woman lawyer on the team of defense lawyers.
The defense team consisted of Solomon C., who led the defense team, as well he should. Johnny Hardwick, who is now the presiding judge of the circuit court. Troy Massey, who was in private practice for many years before retiring, only to run for a district court judgeship, from which he recently retired, and me.
Yeah. And without going into details about that case, which is well documented, what did that case mean for the city of Montgomery? It surely stands out. I know that organizations arose because of it, and as I said to begin with, when you say Todd Road even today, it has a meaning.
Well, bear in mind, Todd Road occurred in '83. You asked me previously what differences I found when I came back in '75. And my analysis was superego, ego, and id. Todd Road was the id. Todd Road demonstrated that beneath the surface, nothing had changed. One, the presumptions about how black people lived their lives by whites had not changed. But more importantly, far more importantly, the racial supremacy that inundates white existence leads to the assumption that I can do whatever I want to do, including entering your house without telling you why.
Unannounced.
Unannounced.
And
with my gun
with
drawn.
No identity of
Yes.
law enforcement
Yes.
insignia.
It's the presumption of the privilege I have to do what I want to do as it pertains to you, and acting on that presumption. That's the id. Yes, that I think it taught everybody that. It also revealed, which of course is what led to the development of these organizations, it also revealed that there was no non-governmental avenue for expressing opinions about our city. The closest that it came to a non-governmental avenue was an entity that may as well be a part of the government, and that's the Chamber of Commerce, which then was practically all white.
But apart from that, there
Yes.
was not in this city an organization, a venue for black and white citizens
Yes.
to express themselves
To
about
each other.
how their institutions were or were
Yes.
not working.
With mutual respect.
What difference did Todd Road, that is your participation in the defense of those blacks charged with assault, what difference did that make in your career?
Well, on the surface, it certainly made me a more well-known entity in the city, because Todd Road was strongly monitored by the press. There was something in the newspaper almost every day. And although the intrusion took place on February 6th of '83, the trial did not end until December. The legal matter did not end until December of '83. And I recall that this time in 1983, we were into the trial of the case because we tried the case on Thanksgiving Day of 1983.
And this was a state court trial.
This was a state court trial. So throughout the year, as we define 2020 by reference to the pandemic, we can define the year 1983 in Montgomery by reference to Todd Road. So yes, you know, it certainly made me a more familiar name and face in the city. But you're asking me what difference it made to me?
Yes, yes, yes. How did it inform thereafter the arc of your career in private practice?
It certainly generated a clientele. I did sense that it generated a clientele. It encouraged people to come to me for legal services who probably would not have otherwise, and or who came to me for legal services specifically to help an underserved clientele, or repressed clientele, or oppressed clientele. It also familiarized me more with the circuit judges and how they worked. But it also helped me to appreciate that the real answer to what I was trying to achieve as a lawyer lay in federal, not state court. One of my real disappointments in the Todd Road case, and of the 4 lawyers, I was the only one who who just objected altogether. I just thought it was awful. The case was ultimately settled without any of the Taylor men having to go to jail. But one of the salient requirements that the prosecutor, the DA, had at the time was that the Taylors relinquish their right to pursue any federal action under Section 1983. I just thought it was scandalous.
And that experience then, I suspect, cemented your preference for federal court litigation.
Yes, absolutely.
And of course, during the dozen or so years you continued there from Cottage Hill in your solo practice, you still had quite a few forays in federal court across the state, particularly in prosecuting or pursuing claims in job discrimination.
Yes.
Whether against governments or private, or the private sector. I can't conclude your solo practice without highlighting the years-long experience you had pursuing for black deputy sheriffs job discrimination claims against the county of Montgomery.
Well, even before then, there were 2 major class actions that I participated in that I didn't start. When I was in nursery school at Miss McGinty's, the person who swept was always superior to the one who held the dustpan. That was definitely an inferior position. So I held the dustpan when Oscar Adams was appointed to the Supreme Court, Alabama Supreme Court, and I held the dustpan when U.W. Clemon became a federal judge in Alabama in 1980.
You picked up
I picked up class actions that they had handled.
About those 2.
Oscar Adams' class action was against the Alabama Department of Youth Services. It was a race discrimination case based on Title VII against DYS. So when Oscar joined the bench, I became substitute counsel in his place. And
excuse me, just to make sure the record is correct, the bench that Oscar joined was
Alabama Supreme Court,
where he distinguished himself because theretofore there had not been a black justice on that court.
No. And he was appointed to that court by Governor Fob James at the time. That was in 1983, same year as Todd Road. So anyway, I became lead counsel in that case. The lead plaintiff was Jessie Morrison, a female who worked at Roebuck. So we ultimately prevailed in that case, and when UW Clemon 2 years earlier, became a federal judge as the first African American federal judge in Alabama, I held the dustpan for him by becoming lead counsel in his race discrimination case against Fort McClellan. The Fort McClellan black employees had a class action. And I tried that case on July 4th. It began before then, but Judge...
Was it Proust?
No. Previous chief judge in Birmingham. The names. And it's such a well-known name. I'm sorry.
I can't.
In any case, required us to try the case on July 4th. And so that case ultimately ended in settlement. And so by the time I brought cases against the police department, I'd worked in at least 2 other class actions. So I had an understanding of how to manage a class, which really is an undertaking when you're handling litigation.
Sure. So managing the class of black sheriff's deputies when you
Sam
took on
Pointer.
Montgomery County. Judge Pointer.
Yes, it was Sam Pointer. Thank you.
I think you were there in Anniston over July 4th trying that case.
Yes.
Another sacrifice as a mother.
Absolutely.
We'll talk about that in a second as well. But one of your other more memorable class actions was against the county sheriff here in Montgomery.
Yes.
And
yes.
what
it is the
are
most
you most gratified? It is the most memorable?
Yes.
Why is that so gratifying for you?
It's gratifying because it had, and still does have, a legal imprint. But it also has a social and cultural imprint. And I'm just so proud of the officers in the sheriff department. The trajectory of that case began with a long-time Montgomery sheriff who was consistently unopposed in elections, who used the N-word unabashedly, I can't say proudly, but certainly unabashedly, whose officers used that word in referring to African American defendants and colleagues, who refused to employ any African Americans outside of the jail where people were incarcerated, who refused to promote any African Americans in his office, to today when we have an African American sheriff. The 4 lead plaintiffs in that class action were courageous. They worked in law enforcement. And in law enforcement, there is a blue wall. One does not challenge one's colleagues on any ground. One adheres to the code, whatever that code is. It is as much omerta as practiced by organized crime in other parts of the country. And they were all confined to positions, and they wanted to be professional law enforcement officers. They wanted to be promoted. They wanted to work outside the jail. And so I'm proud of that case for that reason. And they inspired their fellow officers to come on board and demand that they be treated with respect. This sheriff had been sheriff since the 1950s. I filed the case in 1987. And he hired his first African American employee in I believe 68 or 9. At the same time, Montgomery, as a city and a county, was substantially black, and the defendants whom they handled were substantially black. The areas they patrolled and the arrests they made were of black people substantially. the sheriff had a county station in Raymer, Alabama, and the discrimination was so deliberate. It wasn't in question. There was nothing debatable about the discrimination. It was just the way it was. On the stand in the courtroom before Judge Thompson, when I was trying the case, the sheriff, whose name was Maxim Butler, was asked whether he used the term nigger. And he acknowledged that he had used it and said that it was just the way they talked. And he did so either in utter ignorance of its impact or utter disregard for its impact. And so naturally, those working under him followed suit. That is the environment in which those officers were working in the late 80s. Mm-hmm. So that is why I say it was the most important. That case was decided in their favor in 1992, June of 1992, resulting in substantial legal fees for my co-counsel, who is seated before me. And
let's just say that you certainly made a difference, not only in that case with the injunctive relief that today has the Sheriff's Department reflecting a totally different, unimaginable profile. And anyone who takes the time to examine your record during your solo practice will find a consistency about the difference made for ordinary people trying to live and work and enjoy a quality of life in their places of employment in their lives. We could spend hours analyzing your solo practice.
May I say just one more thing?
I was simply going to give you an opportunity to highlight anything that's particularly memorable to you or you want to be remembered for during that practice before I segue into what you did while practicing law that had such an impact on organizations and associations. So let me pause and give you an opportunity to fill in the blanks for anything I did not cover about your lawyering before we talk about your serving in addition to being a lawyer.
If someone asked me my biggest regret in lawyering, it would be that I didn't win a single police brutality case. I prevailed or helped my clients to prevail in employment discrimination cases, but the police brutality cases were hard. They were just hard.
Was it more than the blue wall that
oh my goodness,
kept
yes.
you
yes.
defeated?
Yes. My first federal court police brutality case was in representation of a man who was arrested in Opelika by a state trooper, placed in the back of the car, taken to the woods, beaten, and then taken to the jail. I lost those cases perhaps because I didn't do everything I should have done. I certainly should and do take responsibility for the losses because I believe with all my heart that all of them were justified and that the clients were acting in good faith. But other than my failures as a lawyer, you know what I lost the cases to?
What was that?
Qualified immunity. I so steadfastly identify with today's push by organizations and lawyers alike to have the Supreme Court modify qualified immunity.
It's a powerful shield.
It is an unbelievable shield, and in many instances just dispositive.
Yes.
It's just hard to get around. So qualified immunity helped to bury me in my quest to secure justice for those who were abused by law enforcement officers.
Thank you. We want to transition in just a moment to your success in taking a lot of add-ons that weren't necessarily practicing law, but clearly made a difference within not only the legal community, but the overall community, and that's where we're going to turn.